MLA08-56, Brown.
I move that we approve MLA 08-56 with conditions.
Conditions of the plan commission.
Yes, with the conditions as noted by the planning commission and are outlined on the map.
I'll second it for the sake of discussion.
Okay, move to second. We have any discussion?
One of the things that certainly moved me were the photographs, aerial photographs taken in 2005 and an earlier aerial photograph taken in 1994, both of which are available on the county website on the parcel maps. It seems to be clear that the area that the applicant wishes to have noted as agricultural has been agricultural. In the staff report, the comment was made that if a change was to be made, it should have been made at an earlier time. However, I worry that this places a burden on property owners who may have a perfectly reasonable thought that areas that they've always considered to be agricultural and appeared to be agricultural and were used as agricultural would automatically be considered. And therefore, I go along with the Planning Commission's recommendation with the modifications to the initial request.
I had a concern in the staff report. It's on page 1-15. Their analysis, they point out that while pasture land does exist within the zone forest land, the comprehensive plan prohibits the county from rezoning the zone forest land to agricultural land. Right before your statement there. Perhaps does staff want to elaborate on that any?
There is a GMA statute that discusses resource lands and the establishment of resource lands in the jurisdiction's comprehensive plan. It provides for forest land, ag land, and mineral land designations. And I believe it's also reflected in our code, but I'm looking for the reference now, that disallows rezoning forest land to agricultural land. And this is, in a sense, protective of forest land, forest resources.
This is not a forest resource land.
Well, I believe it is, right?
That's what's designated. In reality.
Right, and I think, and I recognize that from staff. However, it appears to me that it may have been misdesignated as forest resource when in effect it was agricultural. Most likely at the early time of the designation. And I hate to see property owners punished for just not having noticed at that moment.
This was a very involved process in this comprehensive plan. It's not likely that too many people weren't aware of it. If I had lines going out of the courthouse, I understand that people waiting to testify back in those days. guess I have a concern, I mean, the appropriate process really would be to amend the comprehensive plan and then go through with, I mean, in terms of amendment, to allow this, and then to go through any proposals to that comp plan, would be an opportunity to do that during the update. But I have a problem, I guess, with having something directly say you can't do it in the comprehensive plan and not honoring that at this point. We're obligated to follow the comprehensive plan that's adopted by ordinance, and it's really what we have to go by.
If I could answer your first question a little bit more, on page 2-37 of the staff report,
2-30.
2-37, it explains the reasoning behind the staff position about rezoning forest lands, and basically it prohibits subdividing forest lands, and our final conclusion is rezoning to rural residential would in essence circumvent provision NRP 4.1 and be inconsistent with the comp plan.
Then I would ask of staff, what if there's been an equivalent of a typo or an error initially in designating this property so that an error, what was designated as commercial forest was actually agricultural. And you could look at it and say, oh my gosh, obviously this is agricultural. So how can we correct this error? Because that's kind of how I'm looking at it.
It would be through this process of a comprehensive plan amendment. You cannot say it was a map. You can't process it as a correction to the old comp plan adoption, but it's going through this process of the amendment.
And going back to 1998, so that's 10 years ago, we did have a criteria in the comp plan that discussed mapping errors. And at that point, you could come in and say there was an error. And we used that in the case dealing with Chevy Chase Golf Course and Black Point Properties and Camp Parsons. We went through the process, and under appeal, we went to the Growth Management Hearings Board. And they said to use a map correction process as errors was non-compliant with the Growth Management Act in that it prohibited public participation. So as a result of that hearings board decision in the order, we removed the criteria for map corrections out of the 1998 comp plan. It no longer exists in there, and essentially the boards say that there is no mapping errors. They are presumed valid the way that they are outlined. I understand the irregularity that you're noting in your common sense approach to this, but Commissioner Sullivan, I think, is the one that indicates the proper process where the NRP 4.1 would ideally be corrected first. That it says that you prohibit bringing the ag land back in. And or the board at the same time can approve this, and you take on the question of your legal discretion of making comp plan amendments. So staff's going to say read NRP 4.1. And Commissioner Sullivan indicates that if you don't like 4.1, you should get rid of that first. I can understand his logic. And Commissioner Austin understands the logic as well, looking at the common sense on the ground, and it appears to be regular.